USDA publishes its final rule concerning highly erodible land. Growers look to verify such designated property to ensure farming activities do not occur, as failure to comply can result in ineligibility for farm program benefits. Roger McEowen with the Washburn School of Law joins us now with some guidance in today's Rural Money segment. Well, Roger, bring us up to speed on this new rule and what it means for farmers.
Well, Tammy, good to be with you today. It is a rule that went into effect August 28th. It is a final rule concerning highly erodible land and the conservation provisions of the 1985 Farm Bill. So we're going all the way back to the days of Swamp Buster and Sod Buster. And the stated purpose, and I'll phrase it that way, is to bring clarity to the delineation process as to how the agency, particularly NRCS, determines whether you have either highly erodible land or wetlands or both on the property, so that you can avoid farming those areas and losing your farm program benefits. That's the stated purpose of what the rule is.
Now tell us about the NRCS delineation process, and do you see the final rule bringing clarity to that matter?
Well, that's going to be the multi-million-dollar question. I'm frankly not sure that it will. I think it may add some confusion. Plus, we just have a new circular that was put out with an effective date of September 1, where USDA NRCS says that they're going to look at their delineation maps and put a triangle with a green dot on those maps where they think they have, in this instance, wetland areas that a farmer cannot farm and without being in violation of Swamp Buster. And then they're going to share that information with the U.S. Army Corps of Engineers and the Environmental Protection Agency, two agencies that, when farmers hear those words, they kind of cringe. So the sharing of information does concern me. The delineation, I think, can create a lot of issues for farmers simply because there's been a whole lot of case law since the 85 Farm Bill showing how difficult it is for the agency to delineate these types of properties, particularly on the wetland side of things. So while the stated purpose, I think, is good, the dirt's going to be in the details, so to speak, and we're going to have to see how this works out as applied to farmers.
Definitely. Now, the NRCS claims in the final rule that it will use the delineation methodology in use at the time of a particular delineation. Do you expect the states to follow this approach?
Again, another good question there. Before the adoption of this final rule, the NRCS had acknowledged that the 96 Farm Bill provision, which changes the rule a little bit, remains applicable because they cited it in their June 17 rulemaking for the promulgation of the state offside method for the prairie pothole states, and those would be your Dakotas and Minnesota and parts of Iowa. But the Iowa NRCS did change its state offside method in December of 18 without following notice and comment procedures. So I really wonder whether this is going to apply uniformly across the states or whether we're going to have different delineation methods that are going to be used in various states, and particularly concerned about the prairie pothole region in the Upper Plains.
Definitely going to have to follow this and see how it all plays out. That's Roger McEowen with the Washburn School of Law. We appreciate that information today.